Good afternoon, everyone. Thank you for joining us for our inaugural Saul session. We're thrilled to have you today. I think most of you know us, but just in case you're new, wanted to introduce you to my partner and friend Adam Fain out of our Chicago office, who co-chairs our cannabis law practice with me. And I'm Jonathan Havens. I'm a partner in our Baltimore and Washington, D.C. offices. And today's session is going to focus on the federal and state regulatory landscapes. We're going to get into lots of exciting topics, things that are top of mind that we've been hearing questions about from clients and stakeholders and friends throughout the industry. Before we do that, we wanted to remind you that today is just the first session. We've got several others lined up, and we will have a slide showing you the other sessions in just a moment. But we will so here we go. So we've got on April 30th, talking about intellectual property considerations for launching new products. May 23rd, managing labor and employment complexities. June 18th, cannabis M&A, pain points and opportunities. July 16th, mitigating and addressing litigation risks. So we hope you can join us for all of these. These will be recorded. If you can't make a session, please just let us know. And you have our email addresses, and we will be glad to get you a recording. So just to give you a sense of how today is going to work, all of these sessions, including today's, will start at 4:20 p.m. Eastern time. We appreciate your entertaining our feeble lawyer attempts at humor, but we have to at least entertain ourselves. So they're going to start at 4:20 p.m. Eastern time. Going to go about 30 minutes. I think the curated discussion will last around 20 minutes, and then we will leave time for Q&A. So speaking of Q&A, there's a box at the bottom of your screen that says Q&A. If you submit a question there, we will see it. We will try to get to all of the questions. If we don't, we will endeavor to get back to you offline. And rest assured, only we can see the questions, so don't worry that you're asking a question and someone might be able to identify you. But ask away. And so today, the way it's going to work is Adam's going to lob a number of questions over to me, and we are going to get to what I'm sure is on many of your minds. But if we don't get to something that you have a question around federal or state regulatory issues, again, pop it into that Q&A, and we will do our best to get to it. So with that, I will turn it over to you, Adam.
Thank you, Jonathan, and thank you all for attending today. So Jonathan, cannabis rescheduling, it's been in the news off and on for what seems like many months. Can you please give me and everyone on this call an update on where rescheduling stands today?
Yeah, so interestingly, right before we jumped on this call, Twitter was going nuts about news that FDA had issued some new report about the currently accepted medical use of marijuana. As best we can tell, this is recycling of old news that I'm sure many of you on the call already knew. But again, Twitter has been abuzz with it today. It looks like some of the cannabis stocks moved today, potentially related to this, potentially related to something completely different. In any event, again, our take is that nothing new has happened on the federal rescheduling front today. But as Adam, you said, we've heard that rescheduling of marijuana is imminent. But that word imminent has been used a lot, and it's been used way longer than it's appropriate to use the word imminent. So what is the latest? So we have to go back to October of 2022, where President Biden issued a directive from the White House and said, I want the appropriate federal agencies, and he identified them by name, to expeditiously review how marijuana is scheduled under federal law, right? I think, as you all know, marijuana is currently Schedule 1, which by definition, according to the federal government, means it has a high medical use, high potential for abuse, no currently accepted medical use. But what President Biden did that day, he did a few things, but for the rescheduling discussion, the most important thing is said to Department of Health and Human Services, HHS, and Department of Justice, really the Drug Enforcement Administration, which is part of DOJ, I want you to expeditiously evaluate whether marijuana should continue to be in Schedule 1. So HHS began its work, and only in Washington could from October of one year to August of the next be considered quick, but Trust me when I tell you, if you look at all other rescheduling evaluations, that is very, very quick. Um, HHS, really U.S. Food and Drug Administration, my former employer, sent a letter to DEA saying, yeah, in fact, we think that marijuana should move to Schedule 3. Now, remember, this letter, it was leaked that HHS had sent this letter over to DEA, but it didn't see the light of day until January of this year, but it's dated August of 2023. So what HHS said is marijuana should not be in Schedule 1. It should be in Schedule 3. So there is abuse potential according to FDA, but there is medical utility. There's currently accepted medical use. And so we think there are enough controls of Schedule 3 to permit marijuana to move to Schedule 3. Great. Is that the end of the story? Of course, it's not the end of the story because it's the federal government. And now we need to think about the U.S. Drug Enforcement Administration. So DEA is currently considering FDA's recommendation. There's a lot of discussion of, is it binding? Does DEA have to agree? So DEA has historically agreed with FDA's evaluation. They've asked, for some reconsideration points, but they've historically agreed. The big question, though, is timing, right? When is DEA going to announce its decision? What happens then? Can all this happen before the 2024 election? What happens if there's a change in presidential administration? We're going to get into all of that. I'm kind of getting ahead of ourselves, but to answer your simple question, Adam, it's you know FDA has said marijuana should be moved to Schedule 3. We are waiting for DEA. We, meaning our cannabis practice, I think many of our clients believe that DEA will agree that marijuana should move to Schedule 3. The big questions now are timing, presidential election, hearing process at DEA, legal challenges, and what Schedule 3 means. But again, I'm getting ahead of myself. I'm sure we're going to get into some of the details of the questions I just teed up.
Yeah, that was very helpful. Thank you. We hear a lot from clients and other stakeholders about what rescheduling would mean for them. What are some of the most common questions you're getting around this, and what are some of the biggest misconceptions you've heard around rescheduling?
Yeah, so I think I started to address the first part about the questions we're hearing. The big questions are timing and historical precedents, if you want to use that word, about DEA agreeing with FDA, and is FDA's determination binding on DEA? Could DEA go in a different direction? So I'll address some of those, and then I'll address also some of the misconceptions. I guess let's take some of the misconceptions first because it's important to frame the questions we're getting through some of the misconceptions and hopefully quickly dispense with some of the things that we don't think happen as a result of rescheduling, if in fact that happens. So one of the things we hear is people using the terms legalization and rescheduling interchangeably. So it's important to understand right now there is a total federal prohibition on marijuana for all purposes, full stop. Why do we say that? Well, as a Schedule 1 controlled substance, no medical use, high potential for abuse. It's not legal to do anything with marijuana. Now, the small caveats are if you are one of the lucky few who DEA has granted a manufacturing license to, or you're able to conduct research into marijuana, there are some legal-ish activities that can occur. But for all intents and purposes, particularly for those of you that operate within the cannabis industry or advise clients in the cannabis industry, everything is federally illegal. Even if you're in a state that has adult use or medical use, no matter what, it's federally illegal. There's been an understanding, there's been some appropriations riders, there have been some federal policy and position statements, some of which have been rescinded, that all allow the ecosystem to exist how it does now. But it's all federally illegal, which causes a lot of challenges around taxation and banking and intellectual property protection and real estate and drug testing and labor and employment protections, and the list goes on and on. So the big misconception, I think, is that if marijuana is rescheduled, that all of a sudden it's federally legal. You're going to see cannabis dispensaries on every corner. Interstate commerce is going to flourish. There will be no involvement, no need for the federal government to be involved. So states right now, a majority of the states in the United States have a medical cannabis program, and many of those also have an adult use program. But you cannot transport marijuana from, say, Nevada, an adult use state, to California, an adult use state, even though they share a border, because once you cross that border, it's technically federally illegal. We know that consumers likely are transporting product, on their person regularly across borders. Is it legal? No. Is there enforcement? No. But operators aren't, if they're doing the right thing, transporting product across state line because they're just not allowed to. And one of the reasons the federal government has been hands off is there's tight regulation from state to state, and it's all intra-state commerce, not interstate commerce, right? Within one state rather than across state lines. So even if marijuana moves to Schedule 3, it is not federal legalization. It doesn't force any state to say, we are A-OK with marijuana in our borders. So think back, if you're kind of a student of the Farm Bill and the hemp industry, like I am, think back to the end of 2018 when Congress passed the Farm Bill. One of the things it says is, hemp, which is the federally legal varietal of cannabis, it is now federally legal as long as it's 0.3% Delta 9 tetrahydrocannabinol or THC by dry weight. And states, you don't have to be okay with hemp, but you cannot impede interstate commerce. So if you're driving a truck full of hemp from Montana to Washington State through Idaho, Idaho might not be okay with what's on the truck, but they can't impede interstate commerce. So similarly, if and when DEA agrees that marijuana should be moved to Schedule 3, it wouldn't say to all 50 states, you have to legalize marijuana within your borders. But what it would say is you can't impede, interstate commerce. What's interesting though is, and I'm going to kind of disagree with something I just said, which is it doesn't address it, meaning rescheduling from 1 to 3 doesn't address interstate commerce. Congress would need to establish the parameters there because all we would have is just ending the federal prohibition on marijuana. It wouldn't all of a sudden pave the way for could a product grown in Illinois be transported to Washington State. I'm sure states will start to talk about entering into compacts with one another, regional compacts like we've seen states in the Northwest, Oregon, Washington, and California talking about that. They haven't done it yet. They're just only discussing it ahead of ending the federal prohibition on marijuana. So, you know, I think another misconception is that nothing else will need to happen federally. It'll all be smoothed over. There's going to be active regulation from these federal agencies, right? So if you know anything about federal agencies, if you worked in a federal agency like I have, like Adam has, you know that these agencies aren't, flush with cash to go and regulate brand new things. They don't have an abundance of personnel to throw onto new product areas they know nothing about. So this notion that FDA will all of a sudden actively regulate in the marijuana space just because it's now Schedule 3, it just kind of defies logic. And also, there just aren't the, you know, free flowing personnel at FDA and money, frankly, to regulate this without Congress specifically saying, here's money, here are appropriated dollars to go and regulate this. So, I don't see FDA all of a sudden overnight becoming incredibly active. What could change that is Congress, right? If Congress says, all right, now that we have marijuana in Schedule 3, we need a federal backstop here. There's a very robust regulatory environment now at the state level. There is not an active federal regulatory oversight in the industry now. So what, if anything, does Congress do about that? Those are some of the misconceptions. I guess back to the questions we're getting, timing here, DEA process, what is the immediate implication of rescheduling versus what's the more long-term implication? So we've talked about timing a lot. I've kind of hinted at it. Let's get into what does the timing actually look like. So I referenced earlier that the timing here is very important. Why do I say that? Well, as I'm sure many of you know, we're in a presidential election year. Depending on which polls you look at, it could be a pretty hotly contested presidential election. I think some fear that if President Biden loses and Donald Trump wins, that Trump could put the brakes on rescheduling if it's not yet finalized. What do I mean by that? If there's some sort of an action pending at DEA, as administrations do very regularly, not having anything to do specifically with cannabis, things that are pending before, say, the Office of Management and Budget, the agency that reviews all federal rules before they go back to be published by these agencies in the Federal Register. If it's still pending, if Trump wins, his administration could say, we're essentially dumping out all of the things that are pending relating to rescheduling, relating to anything else. So I think a lot of stakeholders have said this needs to get done now. We need to wrap up the process at DEA, and this needs to be finalized before the November elections. If you're looking at the clock and you've studied these past rescheduling dockets, they take a long time. And by the way, most, if not all of them, I think were pretty, I wouldn't say non-controversial, but potentially less controversial than marijuana rescheduling. You know, you might think if you're in the echo chamber of the cannabis industry that everybody's in favor of rescheduling. There are groups that are not in favor of rescheduling, like smart approaches to marijuana, right? And we expect there to be a full fight with the rescheduling. So, the hearing process could take a while. And so that's why people are anxious to get DEA to come out on this and get that hearing process kicked off at DEA. So I'll pause there. I'm sure we're going to get into the details, but
Yeah, I guess one of the biggest implications of moving marijuana from Schedule 1 to 3 is that 280E wouldn't apply. Do you want to talk a little bit about tax obligations, both past and future, if marijuana is rescheduled?
yeah, great question. So we talk about kind of the hypothetical impacts and then the immediate tangible impacts. I think the biggest tangible impact of moving from Schedule 1 to Schedule 3, I don't think I know, is that Internal Revenue Code Section 280E, the provision that, for those of you that are on the call that are in the cannabis industry, has meant a lot fewer dollars coming in your door and a lot more going into the federal government's coffers, would go away, right? It doesn't apply when marijuana is in Schedule 3. So that's immediate. So prospectively, once marijuana is in Schedule 3, that 280E burden goes away. We've heard a lot in the press recently, frankly, because of a lot of the multi-state operators, MSOs, talking about it, some on earnings calls, that they are amending past returns and saying to the IRS, we're seeking a refund of monies paid because of 280E liability, arguing that, for applicability reasons, constitutionality reasons, there's a lot of theories. I'm not going to get into that. That's a completely separate conversation. But no matter what happens with rescheduling, I think the discussion around 280E will continue and get even more robust. But I think it will be discussed a lot more if rescheduling goes through. Why? Why do I say that? I don't know that I necessarily have a concrete theory on that. I just think it's timing is part of this, right? You're hearing a lot of operators, both public and private, talking about how much of a killer 280E is and how unfair the tax treatment is. For those of you, again, that aren't in the cannabis industry, and I know there's some of you on this call, people think cannabis operators make a ton of money, right? That there's all this cash in cannabis and operators are making money hand over fist. Well, some are doing okay, but most, depending on where you are in the ecosystem, your effective tax rate can be 60, 70, 80 plus percent. It's pretty hard to meet earnings goals when you're paying that high of a tax burden. So prospectively, 280E would go away if marijuana moves to Schedule 3. Retrospectively or retroactively, I do think we're going to continue to see operators file amended returns with the IRS and say, we want our 280E liability back. doesn't apply, it's unconstitutional, those sorts of argument.
Right. And I think one thing to make clear is if rescheduling happens this year, while 280 will go away prospectively, it's not retroactive beyond, it most likely will not be retroactive beyond 2024. So that's just something to note for our audience. But let me ask you, something else that's been in the press is the proliferation of these so-called intoxicating cannabinoid products. First, can you explain what those are, what these products are? And second, can you shed some light on their regulatory status?
Yeah, it's a great question. So I talked about the 2018 Farm Bill a few minutes ago. So the 2018 Farm Bill legalized hemp and its derivatives as long as, those contain 0.3% or less delta 9 THC by dry weight. Well, some view there to be a loophole in the Farm Bill. Why do they think there's a loophole? Well, you can have a product that has 0.3% THC or less, but still 5 to 10 to 15 to 20 or more milligrams of THC, enough to produce that euphoric or high feeling, and say that it's federally legal. The federal government hasn't done a great job of defining what 0.3% by dry weight means. Some people think it means a front end calculation, right? In kind of the extract. Some think it means 0.3% of the finished weight of the product, of the gummy or the oil. Suffice to say, if you go to stores in pretty much any state throughout the United States, I don't care what their hemp laws are, you are seeing these intoxicating cannabinoid products. And they are very prominent on the internet as well, right? So these are drinks, these are gummies, these are a variety of products. And the reason it's being discussed so much is these products, among other things, compete with products that are being sold by highly regulated marijuana operators who have incredible compliance costs, from regulatory to, licensing costs, plus 280E burdens, right? If you're in the hemp space, you don't have 280E because you're dealing with federally legal hemp rather than federally illegal marijuana, right? So states are grappling with it. A lot of regulators don't really know how to tell between hemp and marijuana. Some states are banning these products, but you're seeing a proliferation of these products in a variety of states, and particularly in states that do not have robust marijuana programs, right? You can go into towns across the South. You can go, I mean, really, they're everywhere. We have seen some states that have robust marijuana programs say, we are going to protect against these products. And I think behind the scenes, you probably hear operators saying, hey, we're playing ball with you. We're paying these incredibly high licensing and compliance costs. You know, stop allowing our competitors to sell products on the internet and on the streets, for lack of a better phrase. So it's complicated. I mean, these are arguably federally legal products, but and then you see some operators hedging and frankly partnering with these hemp companies to sell products, to sell these cannabinoid products direct to consumers. So, you know, I guess the only thing I would say from a foreshadowing or previewing comment is there was supposed to be a 2023 version of the Farm Bill. Farm Bill is reauthorized every 5 years. Congress couldn't get its act together last year on the Farm Bill or a lot of other things. But we expect this year for Congress to reauthorize the Farm Bill. And will that intoxicating cannabinoid loophole get closed? We're hearing kind of both sides of that. So I can't say for sure whether we think it's going to be closed, but it is certainly not the end of the intoxicating cannabinoid debate.
Great. And we only have a few minutes left, so we'll wrap it up with this question. But there are a large number of states currently with adult and medical use cannabis programs. In your opinion, what states are ripe for expanding these programs, either to offer medical for the first time or to transition from medical only to medical and adult use?
Yeah, great question. So I think the one that's top of mind for me and for our practice and our clients is Florida. Massive, massive medical market. Hasn't popped yet on the adult use side. The Florida Supreme Court is considering the referendum measure, the ballot measure. It seems like that's going to be on the ballot this fall in Florida. We've heard Governor DeSantis hint at that. I mean, he doesn't control the Supreme Court, but I think he's essentially saying that's what he expects. And if that's what happens, it goes forward. I think the support is there among Florida voters. Another state that is within our firm's footprint and many of our clients operate there already from a medical perspective is Pennsylvania. There's this notion that you can't be an adult use holdout for too long when you're surrounded by states that have adult use programs. Well, that's Pennsylvania, right? You've got New York, you've got New Jersey, you've got Maryland. So we expect that Pennsylvania will make moves to be adult use soon. I'm going to put Texas on the list, and some of you might scratch your heads and say there's already a program in Texas. I don't consider Texas to be kind of a fully functioning program. So we expect Texas will make some moves. Um, I think that's probably it for now. I guess the only other thing I would say is, although I don't expect the Sun Belt, so to speak, Sun Belt states to go to adult use soon. Many thought that the Deep South would never adopt cannabis in any form. So, look at Mississippi, look at some of these states, Louisiana and others. So I think once states realize that they have these programs, they can get a lot of tax revenue and the sky isn't falling, doesn't increase crime, doesn't increase driving under the influence. It doesn't increase you know youth uptake or initiation. So I think a lot of these states are getting a lot more cannabis curious.
Great. Well, that's all I have for you today, Jonathan. It's been super helpful. Appreciate your insight. I guess we'll open it up to see if there's any questions from the audience before we wrap it up.
Yeah, I don't see any questions in the queue. We'll stay on for a couple more minutes here, but of course, if you have anything, feel free to put it in the Q&A, or you can feel free to get in touch with Adam and I.
Great. Well, thank you everybody for attending. We hope everyone has a great rest of their day. And if you have any questions offline, feel free to reach out to Jonathan or I, and we're happy to have a call with you or shoot you an email. But have a great afternoon. Thank you.
Thanks everyone for joining.